he's not. He's been missing his testing. And the other thing is that he is apprised at the time of arraignment that if he needed to get his items, then certainly he could do that by use of a civil standby, and he failed. Court calls the case People versus Nicholas Spence.
Assistant Prosecuting Attorney Morgan Brooks on behalf of the people. Good morning again, Your Honor. Christina Costantino appearing with and on behalf of Nicholas Spence. Mr. Spence, can you state your name for the record?
Nicholas Spence.
Where do we want to start with?
Well, Judge, we'll first start with today's the date set for a PCC. I've discussed with my client his right to have a preliminary examination, and that at that examination, the people must prove probable cause that he committed the crimes alleged. At this time, he wishes to waive his right to have a preliminary examination.
Given, all right. Certainly we can do that. His bond currently is set at, well, his bond currently is revoked. At this
Yes,
point.
Judge. So we'd also like to address bond.
So you do understand that regarding a preliminary examination?
Yes, sir.
You understand that the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further review or further resolution.
Yes, Your Honor. Yes.
That's what you want to do?
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Your Honor, for purposes of arraignment, he wishes to stand mute and waive a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 before judge conference.
July 9th, 2024, 1:30. As to bond.
Yes, Your Honor. We are asking the court to respectfully reinstate my client's bond or consider issuing a bond perhaps in the amount of $10,000 with 10% provision. There were 2 issues with regarding his bond. It's my understanding there was a bond violation for some missed tests and also for a violation of the no contact order. Spoken with my client about both of those allegations, and he does admit to both. He indicates he did violate the no contact order. I would like to give the court some background on that. However, the date that he violated the no contact order, he indicates that he received a text message from the complainant saying, "Come grab your stuff," from the home. He went to grab his items from the home, and an anonymous caller then contacted police indicating that he was present at the home. And so, yes, he did have contact. He did go to the home, and that is the circumstances surrounding that. With regards for the missed tests, he has simply put no excuses for those. We've discussed the nature of this case and how serious it is and that he does need to test. He will be testing in the future. He will not have any other issues with testing. He has indicated to me. Should he be released, he would reside in Belleville with his father and his stepmother. He will also be working with his father. They do fencing, installation, and repair. So he will have gainful employment as well as family support.
Not sure I'm going to need a response because the problem, I hear what you're saying, counsel. Problem is he was supposed to be testing. He's not. He's been missing his testing. And the other thing is that he is apprised at the time of arraignment that if he needed to get his items, then certainly he could do that by use of a civil standby, and he failed to take advantage of that and decided to engage in self-help. So his bond will not be reduced to what you're asking. I will set his bond at a $50,000. I'll give a 10% privilege on that, but
10%, 50,000, 10%, 5,000. Oh, this way. Okay.
all other conditions remain in place.
Thank you, Judge.
Case People versus Andrew White.
Edward Rodriguez on behalf of Andrew White.
Your name, sir?
Andrew White?
I have before me a plea form. Is that what we're doing today?
Yeah.
Yes, Your Honor.
Plea form indicates that the defendant would be pleading guilt or no contest to the charge of larceny 200 to 1,000. The 1 year offense upon the successful plea to that charge, count one would be dismissed. The issue of restitution is preserved and there is no delayed or deferred. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right, may I have it sworn?
Right hand, you solemnly swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name.
Andrew White?
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of larceny 200 to 1,000.
Yeah.
Correct?
Yes, that is right.
All right, that's a misdemeanor punishable up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, I do.
All right. You understand what a no contest plea is?
Yes, I do.
All right. 2 things I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. You understand, sir, also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, I do.
All right. Basis for the no contest plea?
Civil liability.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, I do.
All right. You signed an advice of rights form?
Yes, I did.
Any question regarding those rights?
No?
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yeah?
Are you on probation or parole?
No?
Has anybody promised you anything other than
Yeah.
what's been stated here today to get you to plead?
No, they haven't.
Anybody threaten you or coerce you?
No?
You're doing this voluntarily
Yes, I am.
of your own free will
Yes, I'm on.
and because you believe. No, I won't ask that. All right. Court has been provided Ann Arbor Police Department report for their case number 23-31327. Any objection to the court having reviewed that report?
No objection.
All right, court, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
July 19th at 10 a.m. before Judge Perry.
July 19th, 2024. What time? 10 a.m. before Judge Perry.
And Your Honor, if I could address bond just briefly.
Okay.
Based on the plea today, the felony being dismissed, he has another companion case that he took a plea in the 15th district to a similar offense. He's got a $10 cash bond in that case. This case is set as a $10,000 cash or surety bond.
He has a $10 bond on that case?
It was 10%. Okay, well, I got the 100.
I'd be asking,
What is it? Is it $10, 10%?
It was 110%.
Or it's 110%?
I thought it was just a $10 cash bond, but it looks like $100.
No.
Dollars.
Just $100. It's $100, so 10%.
Oh, okay.
So based on this, I'm asking for a similar bond in this case. They both are
What is it?
right now. $100.
No 10%, just $100. Is that what his bond is?
Yeah.
That's what I heard. There's any,
Just typically I would sit and let the misdemeanor plea happen. However, the defendant has no bond in Hingham Police Department. It says fraud and then in parentheses the letter F. I don't know what that that stands for felony or fraud, I don't know. So I don't know any of the details about the case, I just know that his bond is denied in whatever Birmingham has for him. So perhaps we could keep him here rather than keep him before his sentencing date.
You didn't know about that.
I was actually looking it up this morning. I was informed of that this morning.
Got it. I'll deny at this time his motion for bond reduction. I get what you're saying. I'll deny it so that he's here. Bond will continue. Thank you. This is House Case People versus Mark Essenberg.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Essenberg, who's approaching.
Your name, sir?
Mark Essenberg.
All right, I have a plea form that indicates that the defendant would be pleading. Well, it doesn't say how he's going to plead. I'm assuming guilty to
Yes, Your Honor.
count two. Operating while intoxicated, second offense, the 1 year. Upon a successful plea to that charge, count one would be dismissed. No delayed or deferred sentence. Restitution has also been agreed upon in the amount of $330.04. That's the court's full understanding of the agreement.
Thank you, Your Honor. I did forget to write that he will be going to the TV recovery court as well. If we could add that, I apologize.
That addition, that's the court's full understanding. Is that correct, Mr.?
Yes, Your Honor.
All right. May I have him sworn?
Right here. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Mark Essenberg.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, 30 to 90 days community service, fines and cost of up to $1,000. Court could also order any rehabilitative services the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, yes.
All right. And understanding all, and I also have to advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
Understanding all of that, do you still,
Yes, Your Honor.
and to that charge, how do you plead?
Excuse me?
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes.
July 4th, 2023, at the location of Oregon Street near Parkwood Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much? Do you recall?
A pint of Crown Royal, Your Honor.
All right. Were you stopped by the police or was there an accident?
I scraped the car and I think I went back to the vehicle later.
So you hit another vehicle
I scraped it, yes, with my car. That's
or
the
you hit
restitution.
another vehicle?
Yes.
Okay. Did the police arrive at some point?
Yes.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood test?
Yes, Your Honor.
All right. And what were the results?
I'm not sure.
Point two, Your Honor.
What?
Okay. Do you have any reason to dispute those results?
No, Your Honor.
All right. And had you previously been convicted of operating while impaired on at least one of two or at least one of three occasions in the 34th District Court on or about January 26, 2016, in the 14A1 District Court on January 15, 2004, and on January 7th, 1988 in the 14A1 District Court?
Yes, Your Honor.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation as well as screening and assessment are ordered in the 14B District Court. Sentencing in this case will be
July 25th at 10 a.m. with Judge Washington.
July 25th, 2024, 10 a.m. before Judge Washington. On will continue. Thank you. Is Cartrell Roberson.
On behalf of Mr. Roberson, who appears to my right, we state your name for the record.
Carter Roberson, sir.
Thank you.
Your Honor, today is.
Before I forget, happy birthday tomorrow.
Thank you, Judge. I appreciate that.
Yeah.
You know, I feel like now, like that, I got a happy birthday from a celebrity judge like you. I feel like that makes me a celebrity defense attorney by proxy,
Wow.
right?
Wow. Wow. Here's what.
I feel very blessed.
No, I don't know what you did. My staff, it's all over my calendar. I woke up this morning, I saw it on my calendar, I said, who the heck is this? I don't even, but anyway, okay. Well.
But you didn't know my name. I'm a now. No, I'm kidding. But
Not even
I really.
I'm not biting on that. Go ahead.
Today is the date and time set for PCC. At this time, Your Honor, we would like to request one more PCC to see if we can reach a resolution in this. And I would also like to address bond.
Okay, how much time are you gonna need to see?
1 week or 2 weeks, whatever is well, the second one would be the fourth. So 1 week, please, Judge. Because it would either be 1 week or 3 weeks, correct?
1 week, 3 weeks. I also have July 2nd.
We'll do 1 week. So I'm here next week if that works for Your Honor.
Doesn't, but what the heck?
Thanks.
June 27, 2024, 9 a.m. Bond continue. Well, bond,
Yes, Judge.
Bond.
Bond in this matter is currently set at $10,000, 10%. My client is not able to post that. When we were here last week, there was 2 additional bonds. Those bonds were both lower to $1 each. My client cannot, and not in this case, Judge, in a different matter. So, Your Honor, my client, I did talk with him. He is able to post $100. So, if Your Honor would consider lowering to $1,000, 10%, he would be able to make that.
Any response from the people?
Thank you, Your Honor. When my office charged this case, we requested 15,000 as his bond, and defense counsel is correct. It was currently set at 10,000, 10%. At the time that he was arrested for this case, he was in bench warrant status for 2 cases. What's notable about the bench warrant status is that he had been in bench warrant status since August 12, 2019. In one of the cases, it was his 3rd failure to appear in a row on that file that bench warrant then issued, and then he just remained in the wind since 2019. In the other file, his failure to appear to his other warrant was actually for him failing to appear for a violation of probation hearing. So this is not a person who does well out on bond. This is not a person who typically follows court orders. And absconding for multiple years with 2 warrants out for his arrest, he was in possession of a gun. So, Your Honor, at this time, I believe that reducing the bond even further would not be appropriate, especially given that. Your
Honor, if I may just briefly respond. With this case, there are 3 defendants. There was 1 gun allegedly in a vehicle. 3 people have all been charged with CCW. So possession at this point is just an allegation. And then further, Your Honor, if coming to court would be the issue, which I completely understand from what Ms. Hughes just placed on the record. I think a GPS tether would suffice in letting us know his whereabouts and that he would be here at court.
Well, at this point, we're set for next week. I'm going to deny the motion for bond reduction. I'll just keep it the same at this point. We can take a look at it depending on if there's something.
Thank you so much, Your Honor.
Thank you. Court does call the case, People versus Terry Roberts.
Public defender, let me stop on behalf of Mr. Robertson.
Your name, sir? Terry Roberts. Thank you. What are we doing?
Your Honor, I'm asking for an adjournment in this matter. I am working with our legal clerks to get the missing media on the case that ends in 1170.
Okay. How much of an adjournment did you want?
If we can have 2 weeks, Your Honor.
July 11, 2024, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Try to come up here in a minute. Court does call the case, People versus Henry Gardner.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Good morning. Mr. Gardner. Gardner, state your name, please.
Henry Gardner.
Judge in this matter, I'm sorry.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Gardner as well.
Judge, in this matter, we're asking him to set an exam.
And I'd be asking for the same, Judge. In the record, I'm on case ending in 810,
All discovery is complete then.
to my knowledge.
People have their witnesses available the second. Preliminary examination will be set in these matters July 2nd, 2024, 9 a.m. before Judge Washington.
Judge, may I address bond, please?
Go ahead.
It's my understanding that currently the bond is $250,000, 10% on my matter. My client's asking that it be reduced substantially, possibly to a PR with tether if need be. He attends Wayne County Community College. He's not had any trouble in the past 8 years. He can be gainfully employed. He's asking for a large reduction in the bond.
Judge, I'd be asking for the same thing.
Yeah, there's 250,000 as the 10% case. We did request 250,000 in each case. One is an FA with a pistol. The other is one count of firearm possession by a prohibited person. A second offense, felony firearm, and CCW with a pistol. While there are no holds, he does presently have a 14A2 driving case that's up on July 9th. He has a relatively sizable criminal history, including an unarmed robbery conviction, a felony firearm conviction, an FA conviction, as well as some juvenile convictions from the early 2000s. One was a case where the defendant was in a verbal argument with the victim outside of an apartment complex where he pulled out a pistol, fired a shot in the air, and pistol whipped the victim. He was stopped by deputies fleeing the scene. The firearm was recovered behind the seat in which the defendant was seated. And at this point, I think it's just a concern for public safety as well as for the victim in these cases. And we wouldn't be opposed to any modification of bond at this time.
Your Honor, all I can say is, the allegations that he pistol whipped somebody, we deny that. He will have no contact with the victim, and he's just asking if he can substantial reduction in bond.
Prior to the firearm, it was found in a vehicle in which he was a passenger. The owner of that vehicle or the driver was present in the car, so there's no indication that he himself possessed that firearm.
So June 8th, what happened at his arraignment regarding his conduct in court?
Wasn't there, Judge.
I wasn't there, Judge.
Yeah, we want to look at that. He started laughing, started using expletives to the court, basically indicating that it was a useless proceeding. Well, actually said F this to the court. Motion for bond reduction denied, bond will continue. Thank you. Of the people of the state of Michigan versus Patricia Santos.
We're ready
Okay.
in that matter, Your Honor.
O Estado, o juiz está declarando que está chamando o seu caso do Estado contra a senhora Patrícia Santos.
Jessica Blanche appearing on behalf of the people.
That was Jessica appearing on behalf of the people.
Ok, é a Jéssica Blanche, é o promotor daqui do Estado.
Tom Brown, Deputy Chief Public Defender.
E também o defensor público, it is Lon Brown, I thought it was going to be. Did they change
Yes.
the name?
Tom Brown.
Lon Brown, ok. O seu defensor público é a senhora Lon Brown. O senhor Lon Brown.
Appearing with and on behalf of Ms. Santos.
E está se defendendo a senhora Santos, né?
Today is the date and time set for probable cause conference.
E aqui, hoje foi separado esse dia para ver as causas prováveis contra esse incidente.
Based on the information provided in the discovery,
baseado nas informações que foram descobertas,
we will be requesting both criminal responsibility and competency evaluations.
nós vamos pedir a avaliação criminais e possivelmente avaliações criminais.
Those orders have been prepared and should be in the court file.
Esses pedidos já foram feitos, estão cadastrados aqui no tribunal.
A forensic evaluation is ordered.
Se tipo de avaliação forense,
I will set a competency hearing.
vamos fazer uma audiência
For September 19th, 2024, 9 a.m.
9 de setembro, 2024, às 9 horas da manhã.
Bond will continue.
E, claro, a fiança vai ter que continuar, senhora.
Court does call the case of the people versus Michael Horn.
Prosecuting attorney working for us on behalf of the people. But he must have signed out.
What do you mean?
He had notified us to get a bigger examination. I don't know what you said.
What do you expect me to do? In another court where?
I believe it's Wayne County. I could be wrong.
Who's his attorney?
Green Johnson.
Sir, I don't have your attorney. He was here on Zoom. I don't have him here. I don't know where he is right now. I'm gonna send you back. We'll get your case called today, right? And either it'll be with this attorney or somebody else, because I'm not putting up with this.
Okay.
Got it? Somebody needs to find him or find me an attorney. Was the PD originally on those cases? Yeah, on Horn. Because they assigned an attorney on it, and now he's not here. And this gentleman's in custody. Pardon?
From both cases.
You withdrew from both cases, so they need to get me another attorney, then they're not gonna be here.
Mr. Johnson will sign it.
I saw him signed into Zoom, but he's not here right now and his client is in custody. Court calls the case People versus Merrick Lincecum.
Present on behalf of Mr. Lincecum.
Merrick Lincecum? All right, very good. I have the competency report.
Your Honor, I did submit a proposed order.
Yeah.
At the time, we are not objecting to the findings of the report.
All right. Any additional evidence for the people? All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And I've signed the order. What would you like me to then do, Ms. Gaines?
Your Honor, we would like to set this matter for another PCC hearing.
All right. Probable cause conference. He's out. July 18th, 2024, 9 a.m. And we'll continue. All right. Thank you. Court calls case People versus Samuel Lopez.
And Assistant Public Defender, let me stop on behalf of Mr. Lopez, who is approaching.
Your name, sir?
Samuel Lopez.
Thank you. All right, what are we doing?
Your Honor, I'm requesting a 1-week adjournment. Mr. Lopez is coming to our office so that he can review video discovery on Tuesday. So if we can just have the.
I can give you the 2nd or the 11th.
The 2nd should be fine.
Probable cause conference, July 2nd, 2024, 9 a.m. bond. Court does call the case, People versus Ryan Miller.
Andrew Chill is appearing on behalf of the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Miller. Your Honor, I've been in contact with Mr. Miller. He went to inpatient residential treatment at Oakdale yesterday. I'd be asking to adjourn this matter so that we can get independent verification of that.
I don't have an objection. Mr. Overwater informed me of this yesterday.
All right. July 11th.
Thank you, Judge.
2024, 9 a.m. These are older files. Got it. Anything else? That's it for that month?
Yes.
All right, court stands in recess. You can remain seated, everyone. Case People versus Jordan McKinney.
Andrew Chill is appearing on behalf of the people.
Your Honor. Edward Druk is appearing on behalf of Jordan McKinney.
And
I have not had contact with him. Phone number that was provided was an incorrect phone number.
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately. People versus Jeffrey Penns.
Attorney Morgan Moroso.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Penn, who approaches. Yeah. All right. And right here, please state your name for the record.
Jeffrey Penn.
Okay.
Your name, sir?
Jeff Penn.
Thank you.
Thank you. Thank you, Your Honor. And I have provided competency paperwork for the court's consideration.
Forensic evaluation is hereby ordered. Set a competency hearing September 19th.
Yes.
September 19th, 2024, 9 a.m. as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you.
All set.
I'm all set.
You're all set.
Me?
Yes, sir.
Good.
Court calls the case People versus Mercedes Mullins.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Andrew Meyer on behalf of Mercedes Mullins, who's on Zoom. Ms. Mullins, could you state your name for the record?
Mercedes Mullins.
Thank you, Your Honor. Or thank you, Ms. Mullins. Your Honor, this will be a plea, but we don't have the paperwork submitted yet, so we're just asking for a brief adjournment so that can occur.
July 2nd, 2024, 9 a.m. as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Irvin Patterson.
Moroso on behalf of the people.
Assistant Public Defender, let me stop on behalf of Mr. Patterson.
You, Mr. Patterson?
Yeah, he's.
Come on up.
Mr. Patterson, state your name for the record, please.
Irvin Patterson. Thank you.
Your Honor, an offer has been extended by the APA. I just am requesting a short adjournment so that I can discuss it further with the client.
Probable cause conference, July 11th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Your Honor. Thank you, sir. Court calls case People versus Marshan Smith.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Smith, who stands to my right. Mr. Smith, please state your name for the record, please.
Mark Smith.
Thank you.
Date and time set for a probable cause conference. We'd ask to set the matter for preliminary examination.
Discovery complete.
To my knowledge.
People have their witnesses available the second.
Yes, Your Honor.
Preliminary examination in person, July 2nd, 2024, 9 a.m. That is before Judge Washington.
9 o'clock back here.
Bond will continue. Thank you. Calls the case, People versus Abadule Sia. Silla.
An Assistant Public Defender, let me sob on behalf of Mr. Silla, who I unfortunately have not had any contact with, and I don't see in the courtroom.
Here every time.
I know he has had contact with our division, and they've been working with him for an extended period of time, but we were just not able to get in contact with him.
Well, I guess we actually have issued much on him before, but he always seems to kind of show up at some point. Bench warrant will issue, bond 10,000, cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Proposed case, People versus, is it Emil Thomas?
Andrew Childers, appearing on behalf of the people.
My apologies, Your Honor. Assistant Public Defender Natalie Pate on behalf of Mr. Thomas, who is present via Zoom. Can you state your name for the record, sir?
Emil Thomas.
Thank you.
Thank you, Your Honor. I have discussed this matter with my client. It is his desire at this time to set this matter for preliminary exam.
All right. And is all discovery complete?
To our knowledge, Your Honor, yes.
People have their witnesses available on the second.
Can we go to the 9th?
Any objection from defense?
No objection to that, Your Honor.
Preliminary examination in person will be set July 9, 2024, 9 a.m. That is before Judge, before me. Bond will continue. Thank you. Thank you, sir. Thank you. Hey, that's it for that block? Wow, Emily, you are the bastion of efficiency.
I know.
Wow, and humble. All right, case, People versus Robert Pate.
Robert Pate. Mr. Pate, state your name.
Oh, there she is. Okay. Pate here. Robert Pate. Not here, counsel.
All right, Your Honor, I did send him the Zoom information. He's not on the Zoom.
He is not.
All right. Your Honor, may I waive his appearance?
No. He needs to be here.
Your Honor, can I get off his Zoom, contact him and get back on?
No. Why don't we just do this? Why don't I just issue a bench warrant because your client's not here. You contact him, you go and try to set aside the bench warrant, and then we'll reset the hearing.
Okay, thank you, Your Honor.
Bench warrant will issue on 10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Call the case, People versus counsel. You guys are going to have to not talk to your client when they're on their way out. These guys got to move these people in and out. Court calls the case. You're not the only one that did it, Ms. Constantino. It wasn't at you. But yours was most egregious. Court calls the case, People versus Tyler Stafford.
Morning, and Your Honor, Andrew Meyer on behalf of Tyler Stafford. Mr. Stafford, could you state your name for the record?
Tyler Stafford.
Thank you, sir. And this is the time and date set for probable cause conference. I am still in discussions with the state regarding a potential resolution. I'm asking for 1 to 2 weeks.
July 11th, 2024, 9 a.m. On continue.
Thank you.
Thank you. Court calls the case, People versus Jaquan Turner. You probably don't want to come out here right now, do you? No.
The back today, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Turner. Mr. Turner, can you please state your name for the record?
Braylon Turner.
Thank you.
And Your Honor, we are just waiting today, so.
He's waiving preliminary examination.
Yes, Your Honor.
Is that correct, sir? Yes, sir. And you understand the preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand you will not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination haven't been waived. Defendant is bound over to circuit court on a single count.
Thank you, Your Honor.
No, he's got to do the rest of it.
I'm sorry. Yes, it's just, we're trying to avoid any conflict, apparently. I apologize, Your Honor. As for the, as to that, Your Honor, acknowledge receipt of information. We stand mute, wait for.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for July 9, 2024, 1:30.
1 second. Thank you, Your Honor.
You can leave now.
All right. Appreciate it.
Continue. Yes, you may.